Yes, hello to everybody out there. And I notice now that I put the wrong time for it starting. Thank you, Mr. Nobody Guy, for pointing that out. Unfortunately, I didn't see it until now, but I appreciate it. And so I guess a lot of people will watch this on the rebound. Uh, so with that in mind, I'm just going to go ahead and we will go forward. And I apologize for those who were expecting to see this at, I guess on the East Coast, it had been 1:30 in the morning. So maybe you might suspect that maybe there was something up, or 10:30 p.m. on the West Coast. But my mistake for not putting AM versus PM. I know how sharp we all are. And anyway, that be that as it may, what I'm going to do today is after I read our jokes for today, I'm going to go over the hearing that happened yesterday in Las Vegas in the court, the receivership proceeding before the new judge, Judge Hardy. I'll give you kind of like the scoop and what was basically said and what I said and where we are from here. Before I start on that, I got to do my jokes for today from Claude. Um, and I just asked him for the most relevant hysterical jokes. August August is just July with less optimism. My lawyer said the good news is that we have a strong case. The bad news is he bills by the hour to keep telling me that. Today is National Lighthouse Day, the only job where standing still and blinking is considered heroic. Summer Fridays are a myth invented by people whose bosses also take summer Fridays. I told my doctor I wanted to stay hydrated this month. He said, drink more water. I said, no, I want. Nothing says August like a 7 day forecast, just the same sun icon apologizing 7 times. And okay, those were okay. I asked for some modifications of that, and yeah, nobody has ever finished a glass of iced tea. They've only stopped. I think that's true. Last but not least, I sent an out of office. I sent an out of office in June email. I have not been employed since March. The system is holding. August has 31 days, which is 4 more than anyone needs and 11 fewer than it feels. The mediator said we were very close. We were in the same building. That was the closeness. I bought a hammock in 2019. I've been standing near it ever since. And that's all we're going to do. Isn't those were fantastic, were they not? Give Claude credit for those fantastic jokes. So even though my all these people, everybody here today are this got to be the top 5% of the IQ chart in the United States because you were all able to figure out that even though I said PM, I meant AM. So congratulations to you all. I'm indebted to you, and I feel like your ability to analyze data is just unmatched by anyone else in existence. So thank you so much. To those of you who weren't able to decipher my chronological missteps and the timing and the confusion that I haven't figured out the difference between AM and PM yet, I apologize to you. And if you're watching this at 10:30 at night, then greetings. Enjoy your cocktail with your video, and we'll go on from there. So, what I want to do is I'm going to give you the scoop about what's going on, what happened yesterday at the hearing, and what's going in the future. So, first of all, in the future, there's a hearing on the 13th, which is in 1 week, which now I wasn't sure I was going to be able to attend, but now I can attend because I had another matter on at the same time that has now been changed, so I can do that. So on the 13th is the application by Trento to intervene into the matter, which means to kind of come in to the matter on behalf of the Trento group and to try to, I guess, get their whatever their deal is presented to the court in front of the court and get it in front of the receiver. My understanding is they've been in negotiations with the receiver for 7 months. Um, in the last receiver's report, the receiver indicated the issue was proof of funds. I had a conversation. I'm going to get to this conversation today with one of the attorneys for the receiver. Didn't specify, but he suggested it was more than proof of funds and that we would know soon. So we will see. We'll have to see how that plays out. The hearing on the 13th is whether the uh, Trento group can intervene into the case, participate, do what they want to do, etc. That I expect there'll be an opposition filed, which has not been filed as of yet, but I expect some opposition will be filed because there usually is, and then there'll be hearing on the 13th. We'll see what happens at the hearing on the 13th. The Receivers Council gave me indication that the discovery as to, and this was as of today, that the discovery as of Alpine and those parties is expected to go forward, and that it's expected that the receiver would be able to use receivership certificates to raise enough money to do audit or something like that, or words to that effect. So we'll see how that plays out. In other words, the receiver could borrow money, even though the receiver at one of the last hearings said they only had 10 grand. It was suggested, although this was not clear, that they could borrow money and that those monies could be used for purposes like the audit, etc. I expect we'll get more detail on that because I expect I'll have a more detailed conversation with the Receivers Council when and I'll just address that in a couple minutes or a few minutes, depending on how long I babble on this particular live stream. And again, thank you everybody for being here who was able to decipher the time problem that Hoffman doesn't understand the difference between AM and PM, but we do. Even if you prefer 7-Eleven over AM PM, thank you for being here. So, yes, so I've done the Discovery Alpine. That was the reference or appearance or the suggestion was that Discovery with regard to the short issue is going to go forward. And as I said, that apparently the receiver will be able to raise funds, apparently to do necessary things, at least pay for the audit engagement, although there is no audit engagement yet, which is one of the points I brought up previously and brought up at the hearing yesterday. So we've talked about the hearing on the 13th. We've talked about the discovery that's going forward. Oh, also on the 13th is a motion for Benintendo to approve his settlement. I've opposed that just because the audit isn't done. I will oppose it at the time of the hearing, obviously. I don't think an opposition or a reply has been filed as to that by the receiver as of yet. I don't know if they are, because my opposition was basically don't do it until we know what's going on with the finance of the company, including an audit. So we will see. Now, as I've mentioned before, but I like to recap everybody, the receiver has indicated, hello there. The receiver has indicated that he is in the process of still negotiating settlements. One of those is that they were suggesting they were doing before was with Reichman, but as of today, they haven't asked for additional time. We haven't seen anything else. But on the 13th, the other thing that's on besides the motion for the Trento group to intervene into these proceedings, which I don't see any reason why they shouldn't be permitted. If the deal ends up being a crap deal, then so be it. But if at this point in time, since we have no better choices and since we don't know enough, I wouldn't be opposed to it, at least for the presentation. So we all know about it and we all can kind of understand what the deal is. So that's also going to be on the 13th. And then I think it's Frank Benintendo's settlement hearing is on that date. And again, like I said, I oppose that because of the audit. My expectation as a judge will still probably approve it, but I wanted to state my dissent, and I have, and I will appear. It appears I'll be able to appear. So those are the upcoming things as of now. I expect other things will be on calendar soon, as you will hear, kind of as I talk about what happened yesterday. So what happened yesterday is, who was in attendance? Members of the Trento Group were in attendance. Their attorney, John Aldrich, was in attendance and made an appearance and indicated that he had filed a motion to intervene and he was going to appear. And he did file a motion to intervene, cited one of my briefs as kind of the need for urgency, etc. Also, there was William Knowles, the attorney for the receiver. Dylan Siciliano was not there for this particular hearing. The receiver did not personally attend, which didn't surprise me in light of kind of some of the issues I raised and maybe concerns he would have because he wouldn't know because it's a new judge. I appeared remotely, although I was in Vegas, but I couldn't stay and had to come back. So I went, came back, then appeared remotely. It was kind of a bizarro thing. So at the hearing, the judge. So this is the way I kind of view it. New judge, Judge Hardy, seemed very nice, very competent judge, but kind of like put it in context. So a judge gets, X number of cases. Again, these are new rules for the business courts in Nevada, in Las Vegas. I'm not a Nevada lawyer, so this is just my interpretation of that. New rules. So there were more business courts 3 months ago. Now there's only two. So the two business court judges, I presume, not only get a bunch of new cases, but get more cases. And they don't have the time nor the inclination. When a new case comes in, it's not like they sit down and they review that new case. Though what happens is the new case is reviewed as matters are brought up in court, and the court has to focus on certain things. And in doing that, that's when the judges get kind of apprised of the new facts. So this was the first matter before this new judge and new court. The judge acknowledged receiving the summary report that the receiver submitted. It was the summary of the prior 7 reports, and he also acknowledged receiving my response to that and my request for relief. Now, my response was I responded to all the points, but I also asked informally that the court set a hearing as to whether the receiver should be terminated. I didn't want to file a motion when I hadn't even appeared before the court because I wanted to get a feel for the judge and the proceedings and where we were going. So I elected a less formal fashion because I knew ultimately I would be able to address the issues that I raised. And if I wanted to file a motion to remove the receiver, I could after that. So what I did is I filed it basically as here's a bunch of stuff that's raised by the receiver's most recent report, and because of that stuff, why don't you set a hearing to remove or consider removing the receiver? I'd spoken to some people, and I indicated I thought it's likely that the judge might say, I'm not going to rule on that because I needed an emotion form, and that's exactly what he said, which didn't surprise me, and didn't concern me. So after he said that, he basically said, so let's hear from the parties who were here, and the parties that were there were the Receivers Council through Mr. Knowles and Mr. Aldrich, who made his appearance, as I indicated, and me. And in terms of like the plaintiffs group, so kind of put everything in context. If you recall, or maybe you don't recall, or maybe you don't want to recall, this case arose out of a plaintiffs group of like 250 people that were represented by another law firm. Once the receivership was established, that law firm kind of has basically just been in the weeds. I don't think they're getting paid. I don't think anybody's paying for them. So in terms of taking, and this is just my impression, my opinion, but in terms of taking any affirmative action for the benefit of shareholders, they're kind of on the outside. And they haven't appeared in a lot of these hearings. They weren't at the hearing yesterday. I didn't see anybody at the hearing, either on Zoom or in person. And they haven't appeared at a lot of hearings. So there really is nobody pushing on behalf of the shareholders. If you're saying the receiver is not necessarily pushing on behalf of the shareholders, there's nobody other. And again, I'm not doing this to get praise. I'm just doing this to get so you have context of how the court is set up. So it's me kind of pushing the position of shareholder. There's the receiver pushing his position. And then now we have Aldrich, who indicated that he's filing his motion and he's going to appear. So the court asks who's gonna speak. First, he heard from the receivers counsel. The receivers counsel kind of very generally spoke. I'm trying to think about any specific point he made. He spoke about the audit again. He, at some point in time, he blamed kind of the circumstances for the delay. And again, this is my paraphrasing. He blamed the circumstances for causing the delay. And then on one part, he blamed he suggested, because I raised why it took so long for the firm to do the audit, and then the principal got Barton. The principal got pregnant, and she couldn't. And he keeps on making this point that about how would somebody know that the principal was going to get pregnant. So that's a good excuse. But here's the problem with that. So now I'm referring to the Barton. I'm kind of deviating, but I'm just making a point. So Barton was the CPA that was hired after Fortune, which was a CPA hired by prior management after the prior CPA, Borgers, was kicked out by the SEC. And before that, prior management had a bad history with auditors too. So we get to Barton, who was chosen by the receiver, and the first person who was hired, eventually she gets pregnant. She can't complete the audit. She has to step out. September. Perfectly reasonable, whatever. What's not reasonable is there's a report, and the Receivers Council didn't address this, but I will address it with them again or address it with the court. There's a report after they've hired Barton, and it says, basically, I don't remember the exact words, but it basically says, after communicating with Barton, we understand the report will be done within 30 days. So this is after Barton's hired, and notwithstanding whether this fantastic woman who eventually got pregnant, who wasn't able to complete the audit, whether she didn't know she was pregnant or did know she was pregnant, if she said it was going to be done in 30 days, the pregnancy has absolutely nothing to do with her representation or ability to complete the audit. And then obviously, since they said it would be completed in 30 days, and we had a subsequent group of auditors also from Barton, also against kind of direction that they choose somebody else, the fact that they haven't completed it, 7-8 months later, suggests that 30-day estimate may not have been like a really good faith estimate. So when the Receivers Council said it was only pregnancy, my view, when you represent it's going to be done in 30 days, the pregnancy is completely irrelevant, and you haven't answered for that. And you still haven't answered for that as of today. So that was the audit. The Receivers Council didn't give, though, a specific indication, contrary to how it's been framed before, that an engagement letter was coming or forthwith, but he gave the indication to the court that the receiver's compensation depends upon, the shares trading, etc., although I'm not certain about that. But in essence, I don't disagree with the premise. I just don't think this is the only thing that the receiver has going, so there may be other options outside of GTII. So I don't find it necessarily, that a slam dunk. But the Receivers Council talked generally about, the things. Hi, Judge. Here's our report. It's kind of a summary of what it was. We're working on the audit, and it's been complicated, and management's been bad, and that's my summary of their dissertation. You could read the court record if not. So then I came on, and I introduced myself to the judge, and I thanked him for giving me the opportunity to speak to the court, and I indicated, I understood about the filing a motion, and my filing wasn't intended as a motion. It was intended to get a written response from the receiver, hopefully to respond to the 5 areas that I thought were big issues that were raised by their most recent report. And I thought the judge, by the way, was listening very intently. I noticed that as I went through, he was taking notes. So I went through 5 different points, and I noted as I each because I was watching him. I noted as I was stating the points, he would write it down. So he has a record of the points I raised, whether that's a permanent notation in his file, I don't know, but I know it's a permanent notation in his head. That's how oftentimes people process something. They hear something, they then write it down, and then they're able to process it. So either way, the point I was trying to make is I was trying to bring to his attention the 5 major issues that I saw that were raised by the last report, and he seemed to note them. And so from this point forward, I think he will be kind of tuned in to those issues. Now, again, as I was saying before, he has a whole bundle of cases, so he really knows nothing about this case, or next to nothing, until he starts reading the papers and going through it. So after kind of going through this first status conference, he knows a lot more than he did before the first status conference, and by the 13th, he's going to know a lot more than he does today. That's kind of the way it goes. So I brought up my point, and then I kind of went through the 5 issues I thought that need to be addressed, and I kind of threw them out. So I kind of suggested that if I file a motion to remove the receiver or change the receivership in any way, which obviously I'm contemplating, these are 5 topics that were raised that are obviously concerned to me. The MSC note, the note I brought up, and the investment. And I went through it, and I mentioned that we have an inconsistency, and also I don't know why the receivership is making this loan at this point in time. And we have the inconsistency between it being designated as a loan versus in an earlier report being designated as an investment. What's interesting is when the receiver's counsel responded, they didn't talk about the investment, and they only talked about the business judgment rule, which is basically an officer or director making decisions on behalf of a company, etc. As long as their judgment is reasonable, they are protected from claims. And so it seemed to me, based upon what the receiver's counsel was stating, that the receiver thought the loan was subject to the business judgment rule, because the receiver could make a loan, and if the loan went bad, then, and as long as he did it in good faith, then he's kind of protected. And that may be true, though that's not my point. Why at one point does it says investment, another point does it say loan? And that was not addressed by the receiver's counsel in any respect. I still think it creates a suspect situation that has not been addressed, and I will be addressing it as when I get to the end. You'll understand. When I say I will be addressing it, you'll understand. But I kind of went through the how you couldn't reconcile the two. The response, I don't think, the response the receiver's counsel gave, I don't think in any way addressed that. So that's 1. 2, the cash settlement. And I referenced here that, I'm not commenting about whether the legitimacy, and there was just 2 settlements, I think, that they were referencing. I specifically said, or generally said, or I suggested or implied that I really wasn't commenting on the legitimacy of any settlement. I don't know whether the receiver's, choice of making a settlement, it makes sense. What I'm commenting on specifically is that in my research, when I was looking up MSC, it seemed like there was a business relationship between the receiver and one of the parties he was settling with, and that should be disclosed. And again, I think that's absolutely true, if that is true, that there's a business relationship, and my research suggested it. And again, not saying that the settlement shouldn't occur, but the receiver should disclose if there is going to be a settlement with somebody that he has a business relationship with, and as of now, that hasn't been the case. So that was the second issue I raised. Third issue is the marshaling of assets. And the point being that the receiver has brought in, let's say, 1 million, and again, these are approximate numbers because it could be more. I said, basically, I don't know what the starting number was, and he says, and I'm not going to dispute, that he's brought in a $1.4, $1.5 million in money. So we don't, I don't know precisely how much should be in the bank account, but where's an accounting? Where's an accounting 2 years into a receivership as to where the money's been spent? I'm not saying that the money hasn't been spent. I'm just saying that we're entitled as shareholders to know how it's been spent. And 2 years is more than enough time. And I heard no response from the Receivers Council as to why an accounting or why it shouldn't have been provided. Their response more was that it's understandable how the money's been spent, all the legal, etc., which I'm not debating. But what I'm debating is we're entitled to see how it's been spent. And since the receivership to this point in time, this is more me to you and to the world at large, since the receivership more or less has clamored about transparency, how about an accounting show us where every dollar has been spent, which should take you about 25 minutes, right? Should be a spreadsheet, touch, corrections, done. It should be done easily. Seriously, you can do it in an hour. This is not like the most complicated thing of all time. But we're certainly entitled to that. How's the money been spent? Why is there less than 10 grand? Those issues. Again, receivership response, not really. Has not a response that I recall that really responded to that. Other than that, it's been expensive, which is not a response. 4, audit. I raised the issue of the audit again. I went through it again. I went through the history, and I suggested that even before the receiver got involved, that the audit was an issue, and the auditor knew he had to be diligent. He knew it was going to be an issue, and the way it's been handled, it's been mismanaged. That was challenged by the Receivers Council. The mismanagement has been challenged, but I said it's been mismanaged, and I went through again Barton, and I said, where's the engagement letter? We're still here today. No engagement letter. Response from the Receivers Council. It's been complicated. There was even problems before the receiver got involved. Didn't address the 2022 year, why all of a sudden they deleted the 2022 year from the receivership. Since it was brought up and since Borgers did it, they suggested it's in that a engagement is near, suggested, but without any specificity. So we left it at that. 5. And again, I went through the audit and I made the same points that I've made a million times. Where is it 2 years in? Where's an engagement letter? The writings of the receiver are inconsistent with the way it's been today. 5, the pending deals. I said, basically, my concern here is for all the stocks trading in expert markets, it might trade 20,000 shares a day. The Receivers Council always states to me when I asked about anything, if it wasn't public, I can't disclose non-public information because people are trading the stock. I would say it's traded in the expert market, very limited trading. So I don't understand it, but they would keep that premise so they wouldn't disclose non-public information. And they said it very blatantly. They wouldn't disclose non-public information because people could trade the stock. Then we get this report that they put out, and they talk about 3 transactions, 2 of them that haven't been disclosed before, including terms. And I think to myself, how can that be reconciled with what they did in the past, where they didn't disclose non-public information? Here they do. And then besides the fact, I said, and I even said this to the Receivers Council, I said it was kind of embarrassing that you put out that 3rd deal with the Korean company because it's so skimpy on details. It kind of looks like BS. So you might have been better just saying there was 3 opportunities and not disclosing that because there were so few details to be available to make it almost seem like you were just responding to a prior filing I did, which I believe is really what happened. I did a not. I'm not referring to my most recent filing, but one prior to that, where I raised the issue, just solely the issue of the audit and of an additive transaction. I thought their response there, where they kind of tried to show the court that they were really being diligent and included that Korean company. I think that was just kind of nonsense, just the disclosure. So at the end, and the judge was very cordially let me speak, let me make my piece. I thought I made a good, clear presentation, so the court understood the problems that shareholders believe exist with the receivership. I had no dreams that there, honestly, that a new judge is going to immediately take action. I think it would take a few hearings, honestly, for the judge to feel comfortable enough to have a feel for all the players and all the facts, and that's kind of how I see it. So at the end of the hearing, uh, the judge said, and he was speaking to me. He said, he asked me, so I prefer if you, and I understand this, and I would do it anyway. I would prefer, Mr. Hoffman, if you met and conferred with the Receivers Council to see if you can iron out any of these problems. If you can't, then go forward with your motion, just indicate in the declaration what you try to do, etc. And he asked me if that was okay, and I said, yeah, that's perfectly fine. I intend to, whatever. After the hearing, I got a call from Bill Knowles, the attorney for the receiver, which I saw later, but I didn't take the call. I wasn't available to take the call, but I saw he called. And then this morning I called him back and we spoke, just in generalities, because the court indicated that they wanted us to meet and confer. So I was following up on that, the meet and confer. I'm going to have this meet and confer with Mr. Knowles' partner, Dylan Siciliano, the gentleman who's the counsel who's appeared mostly in this matter. And we're going to go over those 5 items. I'm going to see what the responses are, if any, to those 5 items. If I'm not satisfied by the responses or otherwise, I intend to file a motion with the court in some fashion to remove the receiver or to modify the receiver's receivership or something along those lines. Now, maybe by that time, there may be other parties involved, other shareholders involved who might want to join or have their own counsel participate. We shall see. But the next step I have after speaking to Mr. Knowles this morning is I will be having some conversation, a meet and confer with the other attorney for the receiver. Then I'll report back to you on that, of course. You'll know kind of what happened, and I'll tell you what the discussion was. And I expect it again probably Monday or Tuesday of next week. And then I will, based on that discussion, based upon how the issues have been addressed, I will then decide whether I want to move forward with the motion regarding the receivership, and then we will see. So that brings you up to speed. I expect some type of opposition or other filing with regard to the Trento motion to intervene to be filed either, anytime. It could be filed today, next week, but I expect it to be filed. I'll of course, will report on the contents of that and any response. It was funny, as soon as I walked out of the hearing, I got an email from another attorney who was sitting in the hearing, I guess listening to the argument, who was a receiver who volunteered his services, which was kind of funny. But it was funny that he actually got my email and he passed it on. I just see that somebody sent I don't ever ask for them, but thank you, Brazil guy, for sending that. That's very nice of you. I never request it, but it's always nice to see. Hope you're well. Thank you. So that's where we stand. So I'll have a meet and confer next week. I'll report back to you guys. Hearing on Thursday the 13th. I obviously will attend and report back to you on that. I will, after I decide about whether I'm filing a motion or not, I will let you know. I'll put it out before I file a motion, so it won't be a surprise to anybody that it's coming, and maybe we'll have some impact. Just the fact that there'll be a motion coming, maybe that will have a positive impact. But I will give them the opportunity, as I said, to the court to go over those 5 issues and convince me and explain to me how my concerns are either inaccurate, overstated, or can be alleviated. And again, I'm open to it, so I will listen. And if I think it's if I think that's merit, I will tell you. I think that if there's merit, and if I think it's BS, I will tell you. I think it's BS. But I do have to acknowledge that Knowles reached out to me quickly, and that was very nice, and that's diligent, and I can't argue with that. So that was a good first step. So let me recap. So we have next week, we have 2 hearings, a motion for settlement, confirm the settlement with Frank Benedetto, a motion to permit the intervention of Trento Group into this case, which will be heard on the 13th. I have a meeting confer with the Receivers Council either Monday or Tuesday. We'll see how it works out, to speak about the 5 issues that I mentioned: the MSC note investment, the cash settlement, and maybe an insider disclosure, the asset marshaling and where's the money gone, the audit status, where's the engagement, and the pending deals and what's with this Korean company, and why disclose non-public information now when you haven't all this time. That's what will be discussed. I'll give you a recap of that. After that, I'll decide if we move forward with the motion to get the receiver done, and we'll report about that. And then that's it. So to all of you out there, first of all, I appreciate you being here, and I appreciate you being able to figure out that a fact that I can't tell time. And I'll keep you apprised. Obviously, we'll have more information. I assume at this point in time, now that we have other parties that are trying to intervene, the information will probably come more quickly, and I will report when I have enough to report. I'll do a video when I have, like, I find out information. I'll post it on X, Twitter, so you can find it there. But I'll always accumulate the entirety of it. So next live stream, even if I talk about things on Twitter, I'll put it all together, so we'll talk about it. But we're at a point now where I think the receivership is feeling a lot of pressure to perform, and if they don't, I think that will be the end of the receivership. So I think that's where we are. So let's keep it up, keep the pressure on, keep your interest on. I appreciate everybody's interest. Keep talking about it. Stay alive. Have a great weekend, and we will talk again soon. Everybody be well, and